Good morning, I'm Tom Schmidt again from the Florida Injury Law Firm. This is the second in a three-segment series talking about first-party insurance. We talked about PIP coverage. Now we're going to talk about uninsured motorist coverage. Again, remember, first-party coverage is your own insurance that you purchase or somebody who owns the vehicle has purchased, but it's the insurance that's available to you because of somebody's purchasing power, not because of the person that caused the accident. Now, in a case where you're hit by somebody else causes this accident, and they don't either have insurance or have enough insurance, there's something called uninsured or underinsured motorist coverage in Florida that will kick in if you or the person whose car you're riding in has purchased it. Florida law is very technical in this aspect as well. We talked about the technical aspects of PIP, but there are certain provisions that insurance providers, agents, and whatnot have to follow in order to follow Florida law. In Florida, you are required to be offered uninsured motorist coverage, which equals your liability coverage on your own policy, unless you make a selection or a complete waiver. And so in order for you to do that, and I'm not going to go into the technicalities of it, you have to sign something called a written selection or a written waiver. There's also that same type of a selection or waiver that applies to stacking coverage, a topic that we'll probably talk about at some other time. But uninsured motorist coverage is extremely important because if you're in an accident and the person that hits you or causes the accident doesn't have enough or any coverage, it's the only thing that's going to protect you. It's not required in the state of Florida, so you have to be careful when purchasing insurance. If you want to know more about uninsured motorist coverage, call me. I'm Tom Schmidt at the Florida Injury Law Firm, 407-566-2210.